Howdy Ags, Professor Daignault back again to finish up our two-part series on securing performance. This is part 2 in which we will discuss bonds primarily. However, before we discuss bonds, I want us to review a little bit of what we discussed from part 1. In part 1, we spent a certain amount of time discussing security interests, what a security interest is and what security is. It is this safety net, this something that backs up a promise or secures the performance that you've been promised in a contract. So we looked at a typical example, maybe for some of you that might be a little more straightforward and easy to understand, which is when a bank gives you a loan, say they agree to give you $25,000 today in exchange for your promise to pay them back maybe $28,000 or $30,000, right, over time, depending on interest. And also, because of the risk that the bank is taking, they also say, okay, I'm going to give you this money, but you have to give me a security interest in this collateral, right? You also give the bank some claim on this vehicle that if and only if you stop making payments, they can come in and repossess this thing of value and sell it and help to make themselves whole for whatever amount you did not pay back on your loan. So a lien is as a security interest in real property that functions in the same manner, right? You don't get a lien in the same way that the bank gets a security interest in your car. Liens are a statutory creation, and so this material supplier or subcontractor, whatever he is, remember, has no contract directly with the owner. But if they perform services or supply materials on the owner's project and they are not paid as they should have been, then we can file a lien. Anyone in this chain who does work can file a lien against the real property itself, and that means the owner no longer has clear title. But it also means if this person is never properly paid, this property, which has value, because real property almost always has value, can potentially be sold in order to satisfy this debt. Now, that's only if all of the statutory requirements of the lien are met, and if a lawsuit has been filed to perfect the lien, and then you get a judge to issue an order saying that you can sell this property. And more than likely, before any of that happens, this material supplier, subcontractor, whomever it is, will in fact get paid on the project and be satisfied. But if they aren't, then this real property can be sold right out from underneath this owner. And before the owner gets any money, if they get any money at all, these debts that are left behind are paid out of the proceeds of the sale. And so this is the thing of value. This is the piece of real property, is the collateral, if you will, or the security in the lien, securing the debts or the payments to all of these, the required payments to all of the contractors and subcontractors on the project. So last time I left off with a real cliffhanger question. What happens exactly if you do work on Kyle Field and you are not paid for that work? Or what happens if you do work on, let's say, the White House and you are not paid for that work either? If you are not paid, would you be able to file a lien against one of these properties? So the question I'm asking you is, if we have a subcontractor, material supplier who does work on Kyle Field and they don't get paid, will we allow them to file a lien, right, to stake a claim here on Kyle Field? And then if no one pays them, will we put Kyle Field up for sale? will we put the White House up for sale? I hope that the answer is obvious to everyone. We will not put either of these buildings up for sale. It's not going to happen. And that you cannot file a lien on public property. No liens on public property. So for the most part, that means you cannot file liens on any public jobs that you do. Anytime you are doing public jobs, you cannot file a lien. So what then do you think you do? What is the solution? What is the security that we have if we cannot file a lien? You've guessed bonds. You are correct. Bonds are another way that we provide security, but they work a little bit differently. The security, the thing of value for a bond, is literally money held by sureties or insurance companies. So let's talk more about bonds. The way a bond works is it is a three-party agreement that involves a principal, it involves an obligor or a guarantor, which is almost always going to be the surety, and it involves an obligee or a claimant. Now, when we talk about bonds in construction, there are several different types of bonds, but the two main ones that come up are one, performance bonds. And I'm going to talk more about each one of these in just a minute, and two, payment bonds. And I'm making them different colors specifically. So performance bonds do about what their name sounds. Performance bonds guarantee to the owner that they will get the performance that they contracted for. So these bonds guarantee to owner their performance they contracted for. So that means that they're going to get the building in accordance with the plans and specs at the price that they agreed, including obviously all change orders, additions or deductions. And payment bonds guarantee to lower tier contractors, they guarantee payment to them, payment to lower tier contractors. In the case of a performance bond, your principal is going to be your prime contractor, or possibly if you have a large enough project, some of your main lower tier contractors might also have to take out performance bonds. And so that prime contractor is going to pay money to the surety in order for the surety to guarantee that the obligee or claimant, who will be our owner or our higher tier sub, our prime maybe, probably our prime even if we're in the subcontracting level, gets the performance that they contracted for. So the prime has a contract, right? So this surety is guaranteeing this contract right here, the performance of this contract to this party, but the prime is going to pay for it directly and purchase the bond from the surety to guarantee that the obligee or the claimant gets the performance that they have contracted for. Now, I'm going to clear out all of our blue, and we're going to look at this again and talk about a payment bond. And say, in the case of a payment bond, once again, our principal is going to be our prime contractor and possibly higher tier subs who will purchase the bond from the surety again. And that surety is going to guarantee this performance to our obligee, our claimant, who in this case are subcontractors, lower tier subcontractors, right? And so to the performance to lower tier subcontractors is payment as due. So the surety has to pay these subcontractors if the principal doesn't. So a payment bond functions in the same way a lien does in terms of who it's providing security to. And a performance bond is providing performance of the actual construction work, the promise to perform in accordance with the plans and specs. That is how bonds are fundamentally set up and how they work. At the federal level, we have what's called the Miller Act, and the Miller Act is federal legislation that requires both payment and performance bonds on all federal projects in excess of $100,000. And in every state, we have what's called a Little Miller Act, that even on state-funded projects and probably local projects as well, payment and performance bonds are also going to be required. In Texas, we definitely are required to have payment bonds for any state-funded work in excess of $25,000, and performance bonds are required for any state-funded work in excess of $100,000. Okay, now this is just literally what a bond form looks like, and you'll fill out who the principal is and what the surety's name is, and some information about the principal, and then the penal sum of the bond, which is the penalty sum, which is basically evolved from older language, but that means what's the value. And generally on Miller Act bonds, the value has to be 100% of the contract price. Now, that wasn't always the case, but that is generally what is required now. Every public project requires bonds. Now, Miller Act bonds are only good to two. We have the U.S. government up here, who is our owner, 2 layers below the prime contractor. So we have a prime, and then we have maybe our first layer of subs, sub. And then below these, we have more subs in some cases, maybe just one. Anything after this, these subcontractors below this line cannot make claims on the Miller Act bonds, okay? And so they're left with breach of contract actions after that, unless another bond is required. But the Miller Act requires bonds that are good, the prime contractor and 2 layers below the prime contractor, and that is it. Now, some important things to know about bonds is that bonds are not insurance. And oftentimes, surety companies are, in fact, insurance companies. So companies that are insurance companies will often serve as sureties as well and will often write bonds. But bonds and insurance are very different. Bonds do not transfer risk, okay? Bonds provide a guarantee, but they do not transfer the risk of loss off of the principal. The principal is usually the prime contractor. Sureties write bonds or underwrite bonds because they believe the principal is a good risk and they will not have to pay out on the bond. And that's why you hear commercials for different types of companies that will often say licensed and bonded, right? Because not just anyone can get a bond. When sureties write bonds, they go through an extensive underwriting process, including looking at the personnel who are going to be involved and decide whether or not that company is a good risk and unlikely for there to be any claims on the bond. This is different than insurance. When insurance companies write an insurance policy, there might be an underwriting process. It's For a lot of types of insurance, it's much shorter and much easier. If any of you have ever purchased your own car insurance or other types of insurance, for most of those insurances, you call the insurance company and you give them some basic information about you, and then they'll tell you what they're going to charge you for a policy, right? They aren't trying to determine specifically about whether or not you're a good risk, because when insurance companies write insurance policies, they know that they will be paying out on some of them, and you actually transfer the risk of your loss to the insurance company. When a principal purchases a bond, the surety writes that bond because they believe they will not be paying out to the principal or to any of the claimants or the obligees. They believe the principal is a good risk. And the principal doesn't actually shift that risk. So if we look back at this image, if we're talking about, again, let's start with a performance bond. And if our principal is our prime contractor who is going to actually purchase the bond, albeit pass that cost of the bond onto the claimant, who is going to be our owner in this case, right? So the performance that's promised to build in accordance with plans and specs, right? This is the promise from the principal to the claimant or the obligee, which is our owner. Okay, the prime contractor purchases this surety agreement, which now means that we have, or purchases the performance bond, which now means we have the surety and all of the sureties, boatloads of money standing behind this promise. Okay, when the principal purchases this bond, the principal is still fully responsible for this performance. And the principal can't just say halfway through, oh goodness, I don't want to perform anymore, and walk away because there's a surety involved and the surety will take care of the owner and it'll be fine. The principal has not transferred any of the risk of this contract, okay? We just now have the security of the surety backing up this promise. So, in the event the principal does default on this contract, the surety steps in and they have several options. They can, once the principal has defaulted, the surety has any and all defenses that the principal has for why the work wasn't done. So a principal may have defaulted because they weren't able to make payroll anymore, simply weren't able to make their payments. They may have gone bankrupt, but that may be because the owner wasn't paying. The principal has still defaulted. The surety still has a responsibility. However, the surety has all defenses. Let me use a pen. All defenses and rights of the principal under the contract. Okay. Usually this agreement requires this contract between the principal and the obligor, and the bond contract requires the claimant to usually make a claim within 1 year. Okay, so then the claimant must also timelines, and it's usually 1 year to make a claim, although they may be required to give notice sooner to the surety. And then the surety can do several things. The surety can turn over the penal sum to the claimant. The surety can provide money, provide funds to the claimant. They can provide funds to the principal to complete construction. Or the surety can hire a completion contractor to get the project done. And in some cases, the surety can even self-perform the rest of the contract to build for the owner in accordance with the plans and specs. And the surety will spend up to the penalty amount of the bond, right? But any amounts that the owner still had to pay, because the surety has all the defenses and rights of the contractor, the owner will have to pay those amounts to the surety. No longer to the principal, because the principal has defaulted and is gone, and now the surety stepped in. But the surety has certain rights and obligations. Now, the surety is going to do everything it needs to fulfill its contractual bond obligations to the obligee and the owner. The next thing, after the surety fulfills all of these requirements, is the surety is going to sue the principal for breach of this contract, okay? We're then going to have surety versus principal. And trust me, sureties have a lot of money. The surety is going to sue the principal almost regardless of cost as a matter of principal. This bond contract did not transfer risk away from the principal. It simply provided a guarantee or a security to the owner. So now we can clear all this and we can look at the scenario where it is payment bond. So once again, we can say that the prime contractor is our principal and the surety is our guarantee, or our guarantor or obligor. And now subs are going to be our claimants or our obligees. So what the principal owes to the subs is payment. That's what they owe to the subs. So that means that if the principal defaults on making payments to our subs, our prime contractor's gone, the surety is going to step in and make those payments. Now, if the prime contractor defaults after the end of the project, then it's really just money. If the prime contractor defaults in the middle of the project, there's probably a payment and performance bond. Certainly if it's a public project, you will have both bonds. Maybe this is a good time for me to mention that on private projects, you can certainly have bonds as well. They aren't required by law. It's simply a matter of contract between the parties if they have agreed that there will be bonds on the project. But on our payment bond example here, if the prime contractor is gone, the surety once again has all the same rights, okay, as they did with a performance bond. The surety is going to look first at what does this contract say about my requirements to the obligee, and the obligee or the claimants, the subcontractors' rights and requirements in this contract right here that the parties had. All rights and obligations of principal. And that includes all defenses, right, that the principal may have had to why they didn't pay the subs. The surety has an obligation under this contract for bond to investigate claims that come the surety's way and make sure that any claims, any money that it pays out, it should legitimately have paid out. Because after it's done paying out money, we are once again going to have surety versus principal. Because this surety relationship, we've got all the money now securing or guaranteeing this contract right here, but we have not, with the contract for bond, shifted the risk of loss away from the principal. We have just provided security with a bond agreement, security for the performance that's owed, not a transfer of risk, which is one of the main differences between bonds and insurance. So let's go back to our bonds and insurance page here. A surety's response to the principal when there are claims on the surety's bond is that the principal, the surety is always going to sue the principal when all is said and done. Right? The bond was written on the basis that the principal was a good risk and that no claims would be paid. If they do actually have to pay claims, the principal actually agrees to indemnify the surety. That's the legal word that we would use, which means that they would make the surety whole for any losses that the surety suffers or actually has to pay out. And then again, the surety's response to the obligees is always the same. They always have all of the rights and defenses that the principal had under the particular contract that's being secured. And usually there are time limits by which the obligee must notify the surety and or make a claim. And usually it's a 1-year limit to make an actual claim, but that obviously will depend on the individual contract. But then the surety, in terms of their response to the obligee, they can specifically provide cash to the original contractor so that they can keep performing if it's a performance bond. They can simply provide cash to the obligee if it's a performance bond, or they can pay a replacement contractor on a performance bond. If it is a payment bond, really all that the surety owes the obligees are payment. And after a surety has made payments, appropriate payments, investigated them and made those appropriate payments, if there are in fact payments due, then the surety will turn around and sue the principal to recover any monies that the principal has paid out, that the surety has paid out on behalf of the principal. Because while bonds are similar to insurance, and often insurance companies write insurance and also write bonds, so they act as sureties, bonds do not transfer risk, and that is one of the most significant differences between bonds and insurance. And that is a basic overview of how construction surety bonds work. And I hope that this has been helpful.